This lecture introduces the legal regime that governs the transnational flow of capital, made with the purpose of establishing a lasting interest in an enterprise located in another country. After describing what I call the international investment regime, I will compare its features to a few other international legal regimes, including those covering trade in goods and human rights. Let's define what we're talking about. Foreign direct investment, or FDI, most commonly occurs through a merger with or an acquisition of an existing national business. It may also occur when a foreigner establishes a wholly new enterprise in another country. This is known as greenfield investment, or when a foreign company acquires a controlling share of a local company's stock. The country in which such a foreign enterprise is established is the host state. The nation from which the foreign enterprise comes, usually where it's originally incorporated, is the home state. The essence of FDI is the existence of a long-term relationship between an investor and its foreign affiliate. At the same time, some of the treaties that I will be addressing define investment more broadly and may seek to protect interests owned by a foreigner, such as those due under a contract or in intellectual property. FDI is widely considered to be the principal engine of economic globalization because of its sheer quantity. Even though the trade regime governed by the World Trade Organization, or WTO, gets the bulk of scholarly attention, even when it comes to trade in goods, FDI is very important. The amount of trade in goods resulting from FDI vastly exceeds the amount of dollars involved in pure exports and imports, not involving foreign-based enterprises. But FDI defines the current age of globalization for a more significant qualitative reason. It is not just the sheer amount of capital crossing borders that enables globalization to occur. It is what investment capital does when it arrives in a host state. The impact of trade in goods is not the same as the impact of FDI. As compared to the import of one more foreign-produced good, the permanent presence of a foreign-controlled enterprise results in far more sociological, economic, and cultural consequences for the host state of that enterprise. What most of us associate with globalization is the presence of, for example, Walmarts around the world. When we think of the controversies associated with globalization or economic interdependence, we think of the fact that public utilities or sectors associated with the national patrimony, such as oil or mining, have been privatized and are now often owned and controlled by enormous and enormously powerful foreign multinational enterprises, or MNEs. Or the fact that through globally integrated manufacturing processes, namely multinational enterprises that use the ore from country A to manufacture products in country B for sale in countries A through Z, all countries are drawn into cycles of boom or bust from which no state, no region can escape. FDI does not just drive economic development. When it stops the economies of the world. Thanks to FDI, the most recent economic crisis, widely regarded to have started in rich Western countries like the United States, affects the livelihood of people thousands of miles away. FDI affects, positively or negatively, peoples around the world far more directly than does the import of foreign-produced goods. FDI is an especially potent driver of globalization in lesser developed countries, LDCs, which receive more than one-third of all investment flows. Of course, developed countries remain the principal exporters of capital and, until fairly recently, accounted for about 90% of world outward flows of capital. Today, however, many countries from both North and South, such as the United States, China, Brazil, or India, are significant exporters as well as importers of foreign capital. The perceived threats to sovereignty prompted by foreign capital flows have caused most governments, North and South, East and West, to have a love-hate relationship with it. Most governments acknowledge that they need foreign capital to thrive. Most subscribe to David Ricardo's theory of comparative advantage, whereby capital as well as trade should be permitted to flow freely among nations in order to permit each country to take full advantage of its comparative advantage and promote the most productive use of its resources, both human and other. The entry of foreign firms is widely regarded as promoting employment. encouraging the beneficial transfer of technology and managerial skills, permitting greater access to foreign markets, and creating competition that improves the ability of national firms to compete globally. Over the course of the 20th century, most governments have come to believe that an open, stable, predictable, transparent, and enforceable regime associated with the rule of law is needed to govern both trade and investment flows. This is why they established the WTO and the foreign investment regime that I'm about to describe. At the same time, history tells us that FDI has prompted strikingly similar concerns, irrespective of whether the FDI host state is a developed economy, a poor developing country, or a state that finds itself somewhere in between. Even the United States, a nation that historically encouraged liberal capital flows, has experienced periods of hostility towards certain types of foreign investors. Even the United States, like many states, has now a government screening mechanism that is intended to scrutinize those seeking to invest from abroad. In the case of the United States, that mechanism exists in order to be sure that such acquisitions do not pose a national security threat. Adverse reactions to some kinds of FDI exist everywhere. Today, FDI stemming from multinational enterprises based in emerging nations such as Brazil, Russia, India, or China, for example, sometimes prompts protectionist measures even in rich capitalist host nations. Criticisms of FDI can stem from economic, political, and national security motives. Among the economic concerns are that foreign enterprises will employ fewer nationals or ship jobs overseas, buy up valuable assets or real estate at fire sale prices, put local businesses out of business, monopolize certain sectors, import more foreign-produced inputs, and thereby increase a host state's trade deficit, or shift technology overseas. The political concerns with FDI include fears that foreign enterprises will unduly influence or corrupt politicians, or meddle in national affairs, violate local laws or cultural norms, fail to respect the environment, or undermine certain domestic constituencies, such as the power of local labor unions. Some worry that granting special rights to a foreign investor through international treaties will undermine host states' right to regulate in the public interest. National security concerns include fears that foreign firms will control and compromise access to technology that is needed for the national defense, or concerns that foreign enterprises, especially when these are owned or controlled by foreign governments or by sovereign wealth funds, will act in ways that advance the goals of their parent states and not just respond to the dictates of the market. Even today, when most national economies have been open to FDI for decades and are mutually dependent on the continuation of transnational capital, some forms of FDI, or foreign enterprises from certain countries, is often the first target of reform-minded new governments seeking to protect their national sovereignty. Of course, some governments resist the entry of foreign capital for other reasons, including ideological or cultural concerns. So how has international law developed in relationship to FDI? Well, at least since the colonial era, the protection accorded to foreign enterprises by host states has not simply been a matter determined by national law or sacrosanct domestic jurisdiction. It is no secret that this aspect of international law has been developed by the principal exporters of capital, who have for centuries been interested in protecting their foreign enterprises when these locate abroad. Although customary international law did not require states to admit foreign enterprises, it did insist on a certain level of minimal civilized treatment once foreigners were admitted. Under customary international law, aliens, including alien investors, needed to be treated in accordance with what was called the International Minimum Standard. Violations of that standard, often cast as denials of justice, could lead to the diplomatic espousal of an alien's claim by his or her home state. As is well known, diplomatic espousals could lead to serious tensions between developed and developing states. This even included threats by wealthy states to engage in gunboat diplomacy on behalf of their nationals whenever their properties were expropriated abroad. Today, the treatment of FDI has undergone considerable legalization. The relevant treaties intended to displace old gunboat diplomacy and the threat to use force with the rule of law. This move to law has proceeded along three dimensions: an increase in the number of legal obligations, in the precision of these rules, and in the extent to which states have agreed to delegate certain of their powers to resolve investment disputes. FDI is now subject to much more than the international minimum standard of treatment. It is now the subject of a wide number of legal rules. While the bulk of legal regulation still remains at the national level and consists of local laws and administrative practices, there is considerably more treaty law on point, as well as customary international law, general principles of law, and institutionally generated forms of regulation. These rules are and are becoming ever more precise over time, not only as a result of ever more detailed provisions in treaties and national legislation, but also thanks to ever more elaborate interpretations rendered by international arbitrators who sit in investor-state disputes. As this indicates, the international investment regime is also characterized by the fact that more and more states have renounced their former control over settling the investment disputes of their nationals. In more and more cases, states have agreed that such disputes should be resolved by international arbitrators, that is, third parties that are not within their exclusive control. In addition, they have left it up to the foreign investors themselves to decide whether to take such disputes to international forums. States have also implicitly delegated important aspects of the regulation of FDI to other third parties, such as the International Monetary Fund. The international investment regime has certain defining characteristics. Unlike the WTO governing traded goods, it lacks a single definitive unifying treaty text or a single overarching institution. There is no equivalent to the GATT-covered agreements for investment. There is nothing comparable to the Geneva-based WTO to govern FDI. This is not for lack of trying. The international community has tried to negotiate binding multilateral rules for FDI at least since 1948, when the effort to create an international trade organization that would embrace both trade and investment through the Havana Charter floundered and left only the GATT in its wake. Since that time, there have been a number of other multilateral attempts to negotiate a multilateral treaty to govern FDI or aspects of it. These include a 1961 effort by Professors Louis Sohn and Richard Baxter of Harvard Law School to draft a convention on the international responsibility of states for injuries to aliens, attempts in 1963 and 1967 by the Organization of Economic Cooperation and Development, or OECD, to draft a convention on the protection of foreign property, and that organization's effort to secure a multilateral agreement on investment, the MAI, which ended in failure in 1998. At the same time, soft law experts at global regulation have included a number of famous resolutions by the UN General Assembly, particularly its 1962 and 1973 resolutions on permanent sovereignty over natural resources, and its 1974 Charter of Economic Rights and Duties of States. These efforts, along with the OECD's voluntary guidelines for multinational enterprises, or UNCTAD's attempt, that was never completed, to promulgate a UN Code of Conduct on transnational corporations, have only had a limited impact on the law. Today, however, the international investment regime is most closely identified with some 2,600 bilateral investment agreements, known as BITs or BITs, and an additional 300 or so regional agreements that include, along with trade, investment protection provisions. The latter include treaties such as the North American Free Trade Agreement, or the NAFTA, which has a Chapter 11 devoted to investment, with its own form of international dispute settlement, and other free trade agreements, or FTAs. More countries are today parties to one or more treaties for investment protection, at last count 180 countries, than belong to the WTO. binding commitments to protect foreign investors are also contained in a handful of multilateral agreements designed for specific purposes, such as the Energy Charter Treaty. International investment obligations also exist within international organizations that are principally designed for other purposes. This includes the WTO's agreements on trade-related investment measures, or TRIMs, on services, the GATS, and on intellectual property, the TRIPS agreement. They also include the OECD's legally binding Code of Capital Movements. Other multilateral agreements, such as the World Bank's International Center for the Settlement of Investment Disputes, or ICSID, are essential elements of the contemporary international investment regime. ICSID facilitates the international arbitration of disputes between foreign investors and host states. As I will discuss, ICSID's caseload has increased markedly in the age of BITs and FTAs. An important factor that encourages transnational capital flows is the increased availability of political risk insurance, whether this is supplied by states themselves, by regional banks, or under the World Bank's Multilateral Investment Guarantee Agency, or MIGA. My remaining remarks will focus, however, on BITs and FTAs and the resolution of investor-state disputes these treaties have facilitated. These treaties originated with a German BIT in 1959. They were originally designed to provide a treaty basis for the rights of foreign investors. BITs enable the state parties to give each other mutually credible commitments that each state will reciprocally protect the interests of foreign investors from the other treaty party. To be sure, other treaties, such as treaties of friendship, commerce, and navigation, or FCNs, preceded the BITs as devices to protect the rights of foreign investors. But FCNs were instruments that protected the rights of treaty traders generally, including those engaged in the export of goods. In addition, FCNs relied on state-to-state dispute settlement under the International Court of Justice, or ICJ. With the establishment of the GATT and later the WTO, FCNs were seen as simply less necessary for protecting rights to engage in trade in goods. Capital exporting states like Germany therefore turned to bilateral investment treaties as a more specific instrument whose object and purpose was precisely to facilitate the entry and operation of their investors abroad, as well as to protect the property rights of these investors. Because they were devoted solely to FDI, these treaties were a great deal more specific about the rights to which foreign investors were entitled than those contained in older FCNs. Today's BITs and investment chapters of FTAs accord foreign investors from their respective state parties rights against discrimination, usually cast as requirements to accord national and most favored nation treatment. In addition to such relative rights, these treaties also include some absolute minimum guarantees. They affirm the customary international minimum standard and go beyond it. These absolute guarantees include interstate commitments to accord fair and equitable treatment, full protection and security, fair, prompt, and adequate compensation upon expropriation, and the right to repatriate profits stemming from the operation of their enterprise. As this suggests, BITs and FTAs do not so much displace, but build upon old customary law. Crucially, as I will address, BITs and FTA rights generally can be enforced by the alien investor to whom these rights are addressed. They do not depend on the investor's home state's willingness to pursue their claims under diplomatic espousal. Most BITs and FTAs are intended to get the home states of foreign investors out of the business of espousal and therefore depoliticize such disputes. For the most part, BITs and FTAs do not impose any duties on foreign multinational enterprises. Some investment protection agreements, such as the U.S. BITs of the 1980s and 90s and the Energy Charter Treaty, include another absolute treaty guarantee known as the Umbrella Clause. Under such a clause, the state parties may agree to observe any obligations, close quote, that they have entered into with an investor. Taken at face value, such a clause elevates a breach of contract between a host state and an investor to a treaty breach, and permits the investor to bring an international arbitral claim based on that violation, even if his or her original contract contained no such dispute settlement clause. Depending on the language in an umbrella clause, some BITs may protect any other, quote, obligation that a host state has offered to an investor, even one that is not contained in a contract, such as an explicit guarantee in a government-issued license to operate. The scope of umbrella clauses has triggered conflicting decisions in the course of investor-state arbitrations. Although the 3,000 investment protection treaties that we have contain standard treatment guarantees like the ones that I've just described, the precise ways that these obligations are stated varies from one treaty to another. While investors are given the rights to, quote, full protection and security, close quote, in certain U.S. BITs, for example, investors under the Energy Charter are assured, quote, constant protection and security, close quote. It is typically up to the arbitrators charged with settling disputes under these respective treaties to tell us if these terms should mean the same thing. Arbitrators may be conflicted between interpreting each BIT according to its particular language, as is required by the ordinary rules of treaty interpretation in the Vienna Convention on the Law of Treaties, and a felt need to render consistent or harmonious interpretations for the investment regime as a whole. Some arbitrators may prefer to generate a so-called jurisprudence constante and may be swayed by prior arbitral interpretations relating to other BITs, even when the language of those treaties differ in some respects. Another interpretive issue that these arbitrators are now facing concerns the extent to which international investment law should relate to the rest of public international law, including specialized regimes such as that of the WTO. To what extent should investor-state arbitrators presume that ordinary rules of custom, including the rules of state responsibility, should apply to fill interpretive gaps or to add precision to vague terms in BITs or FTAs? Scholars of public international law will recognize that this is a familiar problem that many international lawyers face, and it is not just a problem in the course of interpreting BITs and FTAs. One way of characterizing the issue is to suggest that it presents problems of fragmentation, as was recently suggested by a study on the subject by the International Law Commission. A concrete example is to consider the potential overlap between the WTO and the investment regime when it comes to interpreting the national treatment and most favored nation guarantees that exist in both. Are the non-discrimination guarantees offered to traders of goods under the WTO comparable to the non-discrimination rights given to foreign investors under BITs and FTAs? Should the abundant WTO case law on point be used in investor-state arbitrations? While it would be helpful to investor-state arbitrators to be able to draw on the abundant pre-existing WTO law on point, the respective non-discrimination treaty provisions may differ in some respects. National treatment and most favored nation guarantees differ among BITs and FTAs, and also as between those treaties and the GATT-covered agreements. For example, the phrase "in like situations" from the typical U.S. BIT is not exactly there in both the Energy Charter Treaty and the GATT. This may suggest a different test for the objective dispute settler. Just what is a like situation when it comes to a foreign investor? That question may not be subject to the same answer when it is applied to a trader of goods. It is not clear whether the law of discriminatory treatment as applied in the WTO can be transferred in whole cloth to particular investment treaties, and indeed it is not even clear whether there is a single test for discrimination or several within the spaghetti soup that is BITs and FTAs. It is also important to note that even if the WTO's view of non-discrimination proves influential in the context of the international investment regime, many other investor rights do not exist in the trade regime at all. The GATT-covered agreements do not mention fair and equitable treatment or full or constant protection and security, as do BITs. There is also no equivalent to an umbrella clause in the GATT, nothing comparable to the property protections reflected in the typical BIT guarantee recognizing the need for prompt, adequate, and effective compensation upon expropriation. There is no mention in the GATT of the guarantee to be treated no less than is required by international law, contained in many U.S. BITs in the Energy Charter. These seemingly absolute rights do not necessarily have anything to do with discrimination against foreigners or trade protectionism as such. To this extent, at least the investment regime seems intent on protecting concrete property rights of non-state parties to a much greater extent than is evident in the WTO. The WTO focuses, by contrast, principally on government measures that have an impermissible discriminatory intent or effect. This is one reason why trade law may offer only limited assistance for those who need to interpret investment protection treaties. BIT interpreters who want to reduce the risks of regime-specific fragmentation by drawing from pre-existing trade law face another challenge. It is not just that the relevant substantive provisions for traders of goods and foreign investments differ. The two regimes, trade and investment, are different in other ways. Even though both the trade and investment regime turn to the rule of law to resolve disputes, the two differ greatly in how they do so.